2, 3, 4.
Hey everybody, welcome to a normal Monday school night type thing. Reading from some more modern American remedies. We got that going on. Microphone's a bit odd. That looks okay. All right. Nearing the end of the semester, we'll have 3 more days of remedies readings and maybe a remedy review and outline, and then remedies final next week. So we're getting there. So tonight we are reading about restoring or restitutionary rights in specific property. We're doing tracing the property. We're doing Re Erie Trust Company, a Pennsylvania case from the Supreme Court of Pennsylvania in 1937. Argued before Kurt, Schaefer, Maxey, Drew, Lynn, Stern, and Barnes, who are all Supreme Court justices for Pennsylvania in 1937. Stern, the justice, writing the opinion. In the estate of W.W. Gingrich deceased, the Orphans Court of Erie County filed an adjudication surcharging Erie Trust Company, the executor, in the sum of $25,819.80, representing cash taken from the estate by the company as commissions, to which, as the court held, it was not entitled. Erie Trust Company having become insolvent and the Secretary of Banking having taken possession as receiver, the beneficiaries of the Gingrich estate sought priority in distribution of the amount of the surcharge. The Court of Common Pleas denied their right to perform over general creditors. Where improperly converted assets of a trust estate are traced into the fund for distribution, a preference has been allowed on the theory that such assets have never become a part of the trustee, but at all times have remained, whether in their original or substituted form, the property of the cestus qui trust, the trust beneficiary. And therefore, the trustee's general creditors are not entitled to any share of the distribution. The claim of the trust beneficiary in such a case is not really a preference or to establish an equitable lien, but rather for reclamation of their own property. An illustration of a claim for unpreferred surcharge would be one based upon an act of negligence or mismanagement on the part of the trustee, as, for example, a failure to dispose of non-legal securities in the trust or allowing trust funds to remain uninvested for an undue period of time. But in the present case, the claim of appellants is to recover as their own property, either its original or changed form, the cash actually taken from their estate by the trustee. We thus come to a principal question involved. Have appellants been able to trace the converted cash of the estate into the assets in the hands of the receiver for distribution? The court below held this requirement had not been met. The $25,819.80 taken by Erie Trust Company from the Gingrich estate was placed in the general cash funds of the company. The lowest amount of actual cash in those funds from the time when the money was taken from the estate until the receiver was appointed was $2,865.40, together with cash items of $1,937.63. The lowest amount of the company's deposits in other banks was $6,373.23. During this period, the company deposited a large amount of cash into another bank. It also invested some of the cash funds in various securities, Church of Covenant bonds, and the Leichner Mortgage Group. The bonds were in the possession of the company at the time the receiver took possession. The mortgage had been foreclosed and the mortgage premises purchased by the company. No trust funds or of other claimants had been transformed without the authority of the company's general cash funds, and no other claim for a preference based upon any such transfers involved in the present liquidation proceedings. It is the contention of the appellee that in tracing the cash taken from the Gingrich estate and mingled with the Erie Trust Company with its own general cash fund, the commingled fund is to be considered as being coextensive with all the cash on hand, cash items, and all cash in deposit with all other banks, and therefore the balance on hand of all such items is impressed with the trust and is subject to recapture, representing the appellate's property interest. So they're saying, okay, trust company, you took money from the foreclosure on the estate that from our estate, from our dead dad's estate, and you took some cash that we had on hand and you invested it, and you also took cash from all these other people because you're a trust company, and you had some stock, and you put it in banks or whatever, and since you put the cash from our dad's estate in with all the other people's cash, and now that's all our money. We're going to get all the money the trust fund had in cash from all the different estates. So instead of the 2,000 that of their money that was taken, they're trying to get 30,000. And this is in 1937. This is serious money. So that's what they're claiming. Let's see here. Moreover, that the securities purchased from any such funds after the conversion of appellant's money, now before the court for distribution, are likewise subject to a constituting a substitute form for the cash converted by the trustee. The principles underlying the tracing of trust funds have been subject to so much confusion in the law in their formation, has thus a checkered history, and it is frequently impossible to reconcile decisions in the same jurisdiction, much less harmonize those in courts from different states. Although it may be said in general that the tendency has been toward a gradual liberalization of the requirements of identification of trust res, the property, res is the property, the progress in that regard has far from continuous. While from early times equity allowed a ceste quae trust to follow the trust property through any change in form or species into which it may have been transmitted, the privilege originally has not extended to the case of money unless the beneficiary could identify the particular bills or coin which had consisted the trust res. But in the famous case of Knockbull versus Hallett, which is a 1879 case, Sir George Russell established the principle that not only could a ceste quae trust trace a cash asset of the trust into a fund in which it had become commingled with monies of the trustee, but that while the latter made withdrawals from the mixed account, the presumption was that the money was thus withdrawn was his own, and the ceste quae could claim the balance that represented the trust property. There evolved the generally accepted doctrine that the beneficiary was entitled to the lowest balance to which the commingled fund at any time became depleted, such minimal residue being considered sufficiently identified as constituting the trust fund. That's a bit odd. No, not equally divided. They get whatever the balance is, they're saying. We'll see. The variance in latter decisions arose from the divergence in viewpoint as to the boundaries properly to be ascribed to a commingled fund. If a defaulting trustee mingled trust assets with his own, did the mixed funds embrace his general assets or consist only of the specific assets with which the trust res had been commingled? More particularly in the case of a bank which had improperly transferred to its own funds cash from an estate of which it was the trustee, could the ceste quae trust reclaim his property from the general assets of the bank or only its general cash funds? Or, adopting a still more rigid requirement, only from the exact cash fund or particular bank deposit in which the cash of the estate was placed or deposited. There are some jurisdictions which hold the trust or property even without any special identification, and even though the beneficiary cannot show it came to some form or other to the bank into the hands of the receiver, can be reclaimed out of the general assets of a bank. The theory being that those assets were augmented and the bank unjustly enriched itself by the appropriation of a trust property, and its general creditor should have no right to profit thereby. This doctrine, however, has been discarded in several of the states which originally adopted it, and the view which presently prevails in most jurisdictions is that the ceste quae trust must identify the trust res by tracing it into some specific funds or assets of the bank. The problem remaining to determine how specifically the commingled fund must be differentiated from general assets. The Pennsylvania, it is not sufficient for a ceste quae trust merely to show that general assets of the trustee have been increased by an unauthorized appropriation of trust property. He must also identify the trust res by tracing it into some specific property, funds, or assets. We have no hesitation in holding in the present case that the deposits of the trustee company into other banks are to be considered together with the cash on hand and the cash items as constituting a single fund sufficiently differentiated from the company's general assets to meet the requirements of the law in regards to tracing the trust property. We are led to this conclusion by the facts that banks and individuals alike generally regard cash on hand and deposits in banks as a unit of cash resources distinct from assets consisting of securities and other forms of personal property. To insist upon a separate tracing of cash funds and credit balances in banks would be to dislocate legal principles from practicalities. The intricacies of bookkeeping and accounting systems, the complexities of bank usage, the difficulty of identifying cash through a series of transactions, the frequency with which balances are shifted from one bank to another, the indiscriminate withdrawals made therefrom are such that ordinarily it would be virtually impossible to distinguish between cash items, cash deposits, and cash in other banks. Indeed, as a legal proposition, there is as little reason to attempt such a differentiation as there would be to establish one between monies kept in different vaults in the same bank, compartments of a cash register, or pockets of a purse. Therefore, even though the appellants have not in this case traced the money from their estate into any particular fund or bank deposit, they are, in our opinion, entitled to the lowest level of cash and cash items in their funds of Erie Trust on deposit in other banks reached between the time when the conversion occurred and the Secretary of Banking took possession of the assets of the company. It follows as a necessary corollary from this ruling that investments made by the trust company after the time of the conversion from funds on deposit in other banks are also subject to the claim of appellants in this proceeding. If the deposits themselves are to be considered part of the fund into which the trust res has been sufficiently traced, any securities into which such deposits were transmuted must be regarded as merely substituted forms of trust property. As early as in Re Ottaway, 1903, it was held that there were a trustee commingled trust monies with his own, from the mixed account purchased an investment in his own name, and subsequently dissipated the balance of the fund. The beneficiary could impress the trust upon the investment. The fictional presumption that the money withdrawn from a commingled fund is the trustee's own should not be applied to defeat the cestate quis trust rights, or the balance left is insufficient to meet the trust obligation. Skip a bit. The application of this rule to the present case entitles appellants, in addition to their rights in the general cash funds already stated, to pursue the balance of their claim of $25,819.80 into the Church of the Covenant bonds and the Leicester mortgage, subsequently foreclosed and now held in the form of a real estate, purchased by the Erie Trust Company out of its general cash fund after the conversion by it of the trust money. The decree of the court below is reversed. The court is remitted with directions to enter a decree in accordance with this court's opinion. So if you own a trust company and you get somebody's money from an estate, don't go invest that money in stock to try to make a profit for your company, or go put it in banks to get interest, because wherever you put that, if somebody screwed up in the execution of the estate, apparently in Pennsylvania in 1937, they can come take all your shit. So that's Re Erie Trust. Now we have Re JD Services Incorporated. Need some coffee real quick here. Sorry for the breach. This is a bankruptcy case from Utah in 2002. So this will probably be a little more familiar and not so crazy. All right. JD Services, the debtor, filed a petition for reorganization in bankruptcy on August 24th, year 2000. On August 28th, one of the subsidiaries deposited a check for $7,250 into an account at Bank of America. The bank improperly coded the check as $725,000 instead of $7,250, and it gave immediate credit for the check to JD Services. On August 30th, the debtor wire transferred $800,000 from this account to a new account at First Security Bank. The parties agreed that the extra $717,750 was included in the transfer. This tracing step is unexplained. Maybe only a nominal balance was left in the Bank of America. Bank of America knows this error and notified the debtor on September 5th. On September 13th, the debtor and First Security agreed to put a hold on the First Security account in the amount of $717,750. No one claimed the debtor had acted in bad faith. The court held that the debtor was unjustly enriched by the mistake, and that the funds mistakenly deposited were held in the constructive trust for Bank of America for so long as they could be identified. Debtor continued to operate a growing concern between August 28th and September 13th for some $6.5 million passed through the First Security account, all in the ordinary course of his business. Some of the initial deposits to the account bounced, and beginning September 1st, First Security put lengthy holds on deposit before making any funds available. When the court refers to the bank, it means Bank of America, not First Security. That's what Glenn E. Clark, Chief Judge, says. Now to the undisputed facts. The parties stipulated to information contained in a report prepared by or at the direction of First Security's branch manager, reflecting the activity within regard to the account. Given the information contained in the report, the debtor's account balance can be analyzed from two different approaches. One approach is to analyze the amounts on deposit as the collected balance, which is the total funds on deposit, regardless of whether or not the funds are available for withdrawal or use by the debtor. The other approach is to analyze the amounts on deposit as the available balance, which is the total funds available to the debtor for withdrawal at any given moment. The available balance approach takes into account only local deposits that have been on deposit for at least 7 business days and non-local checks that have been on deposit for at least 11 business days. If the account balance is analyzed using a collected balance collected balance approach, the lowest intermediate balance for the time period between August 30th and September 13th would be no less than $717,560 at the end of any given day. If the account balance is analyzed using the available balance approach, the lowest intermediate balance for the time period between August 30th and September 13th will be no less than $394,460.47 at the end of any given day. On page 4 of the report shows that on September 6th, the account balance using the available balance approach may have dropped to as low as $162,524.28. However, the trustee and First Security agree that the report does not necessarily reflect the order that individual items were received by First Security or processed during the day. It is undisputed that at the end of the day on September 6th, the available balance was $394,460.47. Discussion. Tracing of funds. If funds held in constructive trust have been commingled, the beneficiary of the constructive trust must trace the funds using the lowest intermediate balance rule. Our constructive trust, like any other trust, must have a trust res at all times. A trust is created in property and exists only so long as there is an identified and ascertainable interest in the property to be the trust res. In circumstances where a constructive trust is declared post petition, the beneficiary of the constructive trust must trace funds to identify the trust res in the same manner as if there were no bankruptcy. Property interests are created and defined by state law. Unless some federal interest requires a different result, there is no reason by which such interests will be analyzed differently simply because an interested party is involved in a bankruptcy proceeding. Quoting from Bankr v. United States, a 79 case. Bankruptcy courts are directed to apply reasonable assumptions to govern the tracing of trust funds, citing Bankr versus International Revenue Service, a 1990 Supreme Court case. To impose the same tracing requirements as are required under state law is reasonable and will cause no greater hardship on the bank than it would experience outside a bankruptcy setting. Furthermore, a tracing requirement is reasonable when weighed against the bankruptcy policy, which demands equality of distribution among creditors of equal rank. If the bank successfully traces its funds, return of the trust res to the bank will not violate the bankruptcy policy because the bank will be receiving its own money and not property that's of the estate. If the bank cannot trace the funds, the bank becomes a creditor to the extent of its loss and must be treated on an equal basis with other post-petition creditors. For the above reasons, the bank must trace its funds held in constructive trust utilizing the lowest intermediate balance rule. Collected balance versus available balance. Under the lowest intermediate balance rule, any funds removed from a commingled account are presumed to be the debtor's funds to the extent the funds exceed the beneficiary's equitable interest. If the trustee deposits other funds into the commingled account, it is generally held the trustee is not replenishing trust funds. New deposits are not subject to the equitable claim of the trust beneficiary, and subsequent withdrawals are presumed to draw first upon the new funds. Applying the rule, if a constructive trust beneficiary may receive the lowest balance recorded after the funds were commingled. In this case, the court is provided with two approaches by which it may trace the constructive trust funds placed in the account: collected balance and available balance. The collected balance approach focuses only on the dates of deposit and withdrawal of funds and ignores the hold imposed by new deposits to the account. The available balance approach takes into account the hold imposed by First Security on new deposits to the account. By taking into consideration the hold imposed upon new deposits, the available balance approach partially rebuts the presumption that subsequent withdrawals following the new deposit were drawn first on the new deposits. The additional information utilized by the available balance approach adds precision to the tracing process and minimizes the commingling of constructive trust funds with new deposits. Of the two approaches, the available balance approach most accurately traces the actual funds that were placed into the account and will be used by this court for purposes of computing the lowest intermediate balance of funds held in constructive trust. Use of the available balance approach to compute the lowest intermediate balance of the constructive trust fund entitles the bank to the return of constructive trust funds totaling $394,460.47. The bank has an unsecured claim against the remaining $323,000.53. Because the claim arose after the bankruptcy petition, it will get a priority in the bankruptcy under the bankruptcy code, not from anything having to do with the restitution it's claiming in this case. Interest. The bank, in its motion for summary judgment, seeks entitlement to the interest actually earned on the funds held in the constructive trust. Because the funds held in constructive trust have always belonged to the bank, it is entitled to the interest actually earned by the $394,460.53 in constructive trust funds held from August 20, 2000 until paid back to the bank in the bankruptcy proceeding. The end. So that was fun. There's a little bankruptcy law, constructive trust law. Just to explain maybe for a little bit because it was probably confusing and it was like mush words. Basically, this company cashed a check for $7,000 in a bank. The bank made an error and gave him $725,000 instead of $7,250. The company then transferred like some odd $1 million. Oh, sorry, transferred $800,000 from that account to another account at a different bank. The bank then realized its error and put a freeze on the money that they transferred to the bank because they realized it was money they shouldn't have been given. The company said, okay, fine, put a hold on that account, on that money till everything gets worked out. They put a hold on that account at the other bank until the money could get sent from the bank back after they reconcile their books or whatever, right? Now, during that time, this company was making other deposits into the new bank that had the hold on the account. Now, because the new bank had a hold on the account, those account deposits weren't crediting to the actual available balance of this company. And so when this company happened to declare bankruptcy, the amount of money that was in that account was frozen because of the bankruptcy proceedings. And so the question is, how much of that money that was frozen that came in after the hold was already put on that $717,000 from the other bank can the creditors in the bankruptcy claim as part of the trust? Because since there was holds on the account, the deposits they were putting in weren't actually showing up in the available balance. Because, if you have a hold on your account, instead of like you drop money at the bank, instead of it depositing immediately, it can be 10 to 15 business days. And so at what point in time do we count the balance that was in that account as what's seizable for the bankruptcy paying off, right? And the bank says collected balance, which aggregate things on like a 10-day basis. And the petitioners say available balance, which is how much is actually there every day at the end of the business day. And that would change the amount that was in there when the bankruptcy petition went through and the amount that the creditor in bankruptcy could recover. And the court says available balance is way better because it's more accurate and actually shows the money that was going in that was not part of this hold that was put on the money from the other bank. And so they say, yep, you can go ahead and get the amount of the available balance when the petition for bankruptcy was filed. And also you can get the money that $300,000 was earning interest on it every day in the bank. So for however long it was in that bank, you can get the interest you earned on that money by merit of it being in the bank too. Not just your money back, but since it was making money in the bank as interest, it was technically your money that got held up. You get the interest as well as the money that was part of the constructive trust from the bankruptcy. So that's what that case is about. And that's all we have for remedies this evening. We have more remedies tomorrow, a little preview. We will be reading Defenses on the Right of Third Parties, talking about bona fide purchasers. So real property, bona fide purchasers, and what their rights are as remedies. We'll be reading a case called Newton v. Porter, an 1877 New York case. That's going to be great. We'll be reading a payment for value case, again, property. Bankworms versus Bank America International, a 1991 New York Supreme Court case. And I think that's all for tomorrow. Yep, so there's 2 cases tomorrow, and that will be the defenses and rights of third parties to property transactions. So we'll see you tomorrow about 9 p.m., folks. Take care. God bless. Tip your waitresses. Hug your kids. Hug your wives. Hug your husbands because they're taking everybody out here. Love y'all. Bye.